what can I say as an introduction? I think this is, we've heard a lot of the analysis, also for the benefit of the two Skype participants, of the existing situation. And we've heard some ideas as to how to move forward. But this is really a presentation or a panel about the solutions, right? So we don't just want to talk about the current state of affairs. We want to look forward and to explore the future pathways. I should maybe briefly introduce myself. I'm Markus Gehring. I teach international and EU environmental law. EU environmental law just for the next 2 years, but after that we call it regional integration environmental law. And I also chair a very interesting initiative, one stream of that initiative, which is the Law and Governance Day at the Climate COP. We had a very interesting inaugural Law and Governance Day on the Friday of the Paris COP, and we're organizing a similar event in the Marrakesh High Court for the 11th of November. So anyone who's interested in law and governance and wants to join the COP, please be warmly invited. Let me introduce Dr. Alexandra Harrington. You've got her bio. She's a long-term friend and based at the University of Albany. She wrote an amazing PhD at McGill University and will present her work on this topic. Also as someone who works very intensely with the human rights community. So, Dr. Harrington.
So thank you all for coming, and I really appreciate this opportunity to get my Skype. Thank you. And I know it's the afternoon panel, so we'll try to be entertaining, and we'll try to be moving on. So I know that, obviously, as Markus said, we've had a lot of discussion about what the current state is, and I will probably be the most negative person on the panel in terms of kind of looking at the last step. So what happens when everything else kind of fails and people have to move and they have moved? What happens to them? It's kind of the idea of we try to avoid it, but when it happens, what do we do? And mitigation and adaptation are wonderful, and obviously they've been tried to scale, but what happens when that comes from? And it ties in, obviously, a lot to Alejandra and statelessness. So I will try not to jump in too much, and if I do, just signal and yell at me. But it's kind of the last resort. How do we handle this? And the issue first kind of came to me many years ago when I was actually discussing this with my doctoral advisor, and we were talking about the Maldives and the issues that surrounded the Maldives. At the time, the Maldives had a now very controversial president who was looking at the reality that his islands might sink, but I hate that term, sink, no longer be enough. And the question was, what would he do as a leader? How could he make sure that his population, not just individuals, but population, was protected? Obviously, it raises all sorts of questions of statehood, and I don't want to trammel into Alejandra at all. So the question was, once they got to this territory that the Maldivian president was looking at, where they would temporarily or permanently reside, what would their status be? And we hear so much today in news from all over about refugees and their status now, mainly political refugees. But the question of status, you come in, we ask for assistance, we ask to come in, and are you allowed in or not? But there's not really an examination of what happens in the future. Okay, fine, you're allowed in. You're allowed into even a territory that's been marked off for you. Say in the case of the Maldives, what they were trying to do was buy a territory or lease territory in, they looked at Australia, they looked at India and actually Sri Lanka, and none of that worked, but they were looking at it. So even if you're allowed in, what is your status? Are you still a citizen of your old country? Are you a citizen of the new country? Do you have refugee status, which obviously we know from certainly discussions this morning would not apply to climate migrants? How would that work? And so this is kind of the idea that motivated this talk that we have now. To the extent that there's the issue of terminology, then is it a climate migrant issue? Is it a climate refugee issue? That's really irrelevant for my portion of this discussion. You can call these people what you would like, but they are being forced out because of climate issues. And so, whatever. One way or another, it's really kind of all the same. So the question is what happens to them when they're there. Certainly, the Paris Agreement was a big step, right? The Paris Agreement was a big step for this issue and started to bring in mitigation and adaptation as methods to avoid this type of issue from happening in places where you could have that type of problem. But mitigation and adaptation are not perfect. And the question is what would happen if they all failed? So, in this context, some of you may have also heard of attempts by Tuvalu and Vanuatu to come up with contracts or agreements with New Zealand and Australia to take their populations when this happens. This has not occurred. There's been a great deal of financial assistance, especially from New Zealand, to Tuvalu and to Vanuatu, but there's been no agreement on taking all their citizens per se. Indeed, there are a number of somewhat increased issues in terms of the ability of laborers, migrant laborers from these communities to come in. So the ability of a wholesale country to come in would be even greater. So I know there's feedback, and I don't want to prattle on forever while there's feedback. So I just wanted to kind of give you a sense of the idea that I've tried to create, which is a model that would serve as, most likely it couldn't be a treaty because of some of the more sovereignty-based issues involved, but that would serve as, at the very least, a declaration of some sort, or framework to handle these issues in advance, right? So to handle these issues, doomsday issues, if you will, before they happen, so that when they happen, we don't have another flood, very bad fun, but flood of people who are coming in and who are to any country. Australia and New Zealand are very popular targets for these issues because the Pacific Islands are the ones that are most likely to have these issues first, followed by the Caribbean. But, how can we construct this framework in advance so we know, so there's predictability? One of my students, when I was giving a talk on this to a class several years ago, told me that we could create a great movie. We could create the Titanic with a state, and people trying to get to someplace safe. So the idea is to figure out how to avoid the Titanic. So this model it's a multi-step model, and it has funding and territory aspects. It also has, obviously, citizenship aspects. So the idea is to address, perhaps first and foremost, what the status of these people will be. Will they be classified as citizens of their state who are perhaps there on a long-term visa? Will they be eligible for citizenship in this new state? Will they automatically become citizens? Most likely the answer to that for any country would be no. Will they be fast-tracked? Will they have some type of asylum? Things like this that do need to be at least addressed in some type of agreement. Obviously, each state will have its own views and each state will have its own opinions, but that's why it's a framework suggestion. The other, and also to go along with that, is the idea of setting out in advance what the receiving states, so take New Zealand as an example, would use as criteria for allowing people in. for refugees to come in? What are these requirements? What may stop someone from being allowed in? So that this is clearly articulated in advance, and so we don't have this kind of ad hoc policy, which can be very, very detrimental, as I think we've seen recently. Also, the idea is to establish the long-term rights of once these people are here, once you have migrants that are here, what do we do with them? Short-term is very popular. Short-term is extremely popular in literature. It's extremely popular in international discussions. Get to safety, obviously, is the most important part. But what happens in the long term? What are their human rights, particularly? What are their human rights? What are the rights of their children? What are the rights of those children that are born in whatever areas they are? Once a new territory, say, for example, the population of the Maldives was able to move to Australia or New Zealand, what would be their rights to leave that enclave? Would it be something like a reservation system we use in the U.S., which I would sincerely hope not, but would it be something like that? These are all issues that we really need to address in advance. Also, the framework would articulate financial assistance. So there's a territorial aspect of where will you go, and then what will you be, and then how are we paying for it, right? Because how are we paying for it gets to be at the core of most people's issues, both in our own private lives and certainly internationally. So my suggestion, looking at the GDF, looking at the Warsaw mechanism from Paris, is to try to basically build on the Warsaw mechanism, right? So that's for loss of damage, but to build on that so that we have something that would create a fund similar to the GDF that would exist to assist in mass relocation of populations from a state that is no longer inhabitable to a new location, so that we don't have this financial pressure. Certainly the financial pressures that we see in Europe on an individual basis, just a large number, but not necessarily from the same community, demonstrate the importance of that. There are obviously many issues, right? There are many other issues, there are many challenges. I don't want to go into them all here because I'm on Skype, and looking at Skype pictures for too long, everyone gets rather bored and their perception's choppy. There are clearly major issues to this, and that's why I'm presenting this to you as a paper I'm working on, including sovereignty, and the idea, obviously all of this is backed by the idea of some level of predictability, which we know is questionable. And also the idea of citizen agreement. So what has not been addressed in this, and what I plan to address in further work on it, is the rights of citizens to say where they would like to go and have that honored and have that at least given some type of agency element when a system or a situation like this occurs. So I do apologize for not being able to join you in person. I will kind of cut myself short here so we can move on, and also, again, not have you staring at the TV screen. But thank you all. I welcome questions, and I think I hand it over to Maxine.
Thank you very much, Alexandra.
Good afternoon, everyone, or good evening. And hello from DC. I am usually based in Honolulu. I'm here in DC for 5 weeks at the Woodrow Wilson International Center for Scholars, and actually looking more deeply at some of these migration questions, and in particular from the perspective of sort of a Hawaii resident who is working in a cross-disciplinary fashion with other scholars in the physical sciences and social sciences to really sort of lend some truth to this notion that we are seeing increased migration from affiliated Pacific Island nations to Hawaii, Guam, and mainland U.S., in particular Arkansas, surprisingly. But and I can say more about that during the Q&A. But we're looking at these very important cross-cutting questions and trying to put some sort of better rigor to our understanding of them, so that the law that we're using to respond is more accurate. But what I want to do today, and is first, thank you for allowing me to participate. I have been with you virtually sort of in the interwebs, if you will, since about 6:30 this morning my time, and I've really learned so much in those few hours that I've shared with you. And so I want to thank you for sharing all these wonderful thoughts. Trust that I have been nodding quite actively in agreement with so many things that have been said, and I'm just really grateful to be here, so to speak. But so what I'm going to do, I was actually initially had a sort of specific mission in my talk, but I sort of shifted it as the day has gone on, and what this is now sort of a collection of thoughts and ultimately an appeal not to jettison climate change and the existential uniqueness of it from the conversation regarding migration and future pathways. And like Dr. Gehring did during his talk, I will first stipulate that everything is multi-causal, including climate-induced migration and displacement. I just want to underscore that I get this from a personal and professional level. Personally, I am I'm a Jamaican immigrant, actually. I grew up in New York City. I now live in Hawaii. My interest in islands and displacement, for example, is itself multi-causal. But I also am a torts professor, right? And most torts, at least the interesting lawmaking or jurisprudence shifting ones, are not simply ones that involve one person punching another in the nose, right? We're now in the world of multi-causal events, and the law has to deal with that. So climate change produces profoundly complex legal entanglements. And I suggest, again, in light of the future pathways theme of this panel, that we continue to move toward those entanglements boldly, right, rather than scrutinize them from a distance. I also want to say that climate and migration seem to be altogether different from your average multi-causal event. I do understand the importance of not overstating its involvement in contemporary population movements, but at least two significant elements of it immediately differentiate, I think. And it's useful for our conversation. Climate change is the result of a series of decisions and differential inputs. They may not have been intentional, and I, again, really understand and respect that, given my orientation towards the common law and tort law in particular. But even minor accidents deserve legal treatment. Second, I'll say that climate change is not a static phenomenon, and this may have been mentioned earlier, but the science of this is really quite significant. It's a change. It's an increase in average global temperature with concomitant impacts, but it's also the rate of change that's increasing over time. So when we think about future pathways, it's really important that we consider that the future we're contemplating is going to be quite different and very much governed by this sort of a stronger climate signal. So in other words, what may seem a deeply entangled, thorny, multi-causal event today will soon have a quite strong climate fingerprint, and we'll need to be conscious of that, and I will consciously echo what Dr. Gehring was saying during his keynote at lunch. He called this, and we tend to call this the Anthropocene, but this it seems to me to be just one version of what the Anthropocene might have been. In other words, I don't think this was an inevitable byproduct of the human experience and the human impact on our planet. So the complexities inherent in climate change and displacement, the phenomenon, the region, I'll focus on one element, which is this notion of naming and legal nomenclature, and that itself has three interwoven concerns. Some of these questions you've heard articulated in different ways, or maybe in the exact same way, but I hope to add a different tilt to my response to those questions. The first is who exactly are we talking about who might benefit from the rights claims? What are the duties that match rights claims based on climate change? And what is the trigger? Climate change itself. Why give it a name? How is this different from survival migration? And we've talked some about this, migrants that are seeking a better life in the face of significant threats to their livelihoods. How is this different from the migration piece? Now, if we look at the specifics around who, obviously something that's been animating a lot of the talks today has been this notion that Jane McAdam sort of has summarized as legal definitions bind states in ways that descriptive labels cannot. That's completely true. Right? So again, despite the use of the popular term climate refugees, it holds no legal significance. Without the right name or legal nomenclature, the rights of those in foreign countries, the status rights, are uncertain. So there's a clear importance of nomenclature in advancing rights, and that's significant. Who we are talking about, though, I think needs to be understood and questioned in how capacious and nuanced the category is. In other words, do climate change impacts happen to the individual or a community? do we craft rights for you, me, or all of us? The dominant paradigm suggests, and there's been a fair amount written about this in the US at least, suggests, and also there's a recovery policy that's built around a dominant paradigm that suggests the former, right, which is that events, disasters, climate change itself happens to an individual. But the current appeals for climate relocation efforts and support, notably among indigenous communities in the U.S., Inuit, the Biloxi, Chitimacha, Choctaw, the Quinault, these are coastal communities in the mainland U.S., they embody the latter. Their refrain is, we must move, right? And how do we manage that relocation? And indeed, appeals based solely on individual rights may also impact informally or more loosely formed communities. And again, an example in the U.S. would be those communities that are disproportionately Black and brown that understand themselves as communities and would likely want to move with those who identify similarly. This question about who also relates to concerns that I have about arguments relying on labor migration, which is often about skilled individual, an individual that is skilled enough to move based on the parameters of a labor agreement. It's divorced from the justice and equity concerns that I think we need to address to achieve truly durable solutions. And it's also overly sanguine when presented as a core solution. I would agree with earlier comments that were similarly stating those concerns. I also would like to say that there's a bunch of reference to climate migrations generally and climate migrants generally. But if we accept that there are different types and categories of displacement, emphasizing the multi-causality of some of the categories obfuscates our need to address the very primary role of climate change, particularly over time, of those in the remaining categories. So we've talked a lot about the plight of small islands, but if we're very serious about that, we need to carve out a clear discussion of how we will help to manage that kind of movement, which I think is actually going to happen on this panel, I believe, right, coming up right afterwards. But we also need to talk about it with respect to those that are subject to top-down planned relocation. And again, this is very relevant to the kinds of relocation that we're going to see even domestically in the U.S. Addressing these categories now might help immensely in crafting and refining sound legal responses to the other categories that right now have a less visible climate signal. So shifting to the second concern, naming duties or obligations, I just want to introduce a concept that was written about in 1990 with respect to climate change and how the law can make climate change worse. It was actually written by a former professor of mine, David Gehring, who some of you may know, and he wrote about the problem of legal feedback mechanisms. And he was borrowing from sort of our scientific sense of or the theories around positive feedback loops in which certain climate phenomenon accelerates the speed with which other climate phenomena manifest. But he was talking about how legal structures, paradigms, specific laws can actually affect climate change and again create this positive feedback loop. So he had said legal feedbacks will not alter the amount of climate change, but will aggravate the suffering that will accompany such change. The greater the change, the greater the aggravation. And given that it was written in 1990, I think it was incredibly prescient. The only thing I would add is actually that legal feedbacks have altered the amount of climate change to the extent that our sort of the Framework Convention and follow-on protocols have not been sufficient in curbing the greenhouse gas emissions and helping us adapt better. But this notion that if we don't sort of manage well our legal infrastructure, we can aggravate the experience of climate change, that seems to resonate really well, especially given this topic. And in particular, not clearly defining environmental duties and their application in practice, I would offer is an aggravation in terms of experiencing that change. And there was some recent literature in the Journal of Human Rights and Environment that noted that in this realm, there is precious little jurisprudence on the environmental duties of states corresponding to or complementing human rights. As Voigt and Grant, the editors, had written, there is, as yet, no theory on how environmental rights may be related to environmental duties. I think this is a yawning gap in our conversation, and I think it would help us do better generally if we make that clear, right? And it's certainly relevant to the specific issues of displacement. When we're asking for obligation, for rights to be respected, we, I think, need to be more specific about, beyond principles and general guidelines, specific about what it would look like to execute that obligation or that duty most effectively. Finally, on the trigger. Who cares that it's climate change? There's a tendency in the what do we do conversation and that discourse on climate change related migration to lump climate change as a driver of displacement with other non-climate-based drivers like earthquakes, tsunamis, disasters, or even destitution, attempting to address this kind of displacement with the same norms and instruments as you would with other kinds of survival migration needs. This entangling of drivers suggests that the difference between the trigger for migration is trivial or maybe just too difficult to parse. In fact, what is paramount, I think most would argue, is to meet the needs of those that are migrating by assigning them and allowing them to exercise their rights, irrespective of the trigger. And this is profoundly convincing. I think, however, it's important to consider that being more specific in naming the trigger here is essential, because it allows us to understand that climate change is not a random, faultless act of God, but something other. Indeed, numerous principles within the Framework Convention, I think, reflect that something other, whether it's the common but differentiated responsibilities or its placement in the loss and damage work stream is just a couple of examples. And the rights and reciprocal obligations we craft would do well by us, all of us, by also reflecting that something other. Removing the rights conversation and the climate justice arguments from our upstream discourse on climate displacement would sanitize or scrub solutions downstream of significant rights language that would be more reparative than simply accommodating. I think there's a key distinction here, particularly in the displacement context. The absence of that kind of downstream, community-level, rights-based solution-making risks perpetuating the initial inequity of anthropogenic climate change, and that's evidenced today by the strikingly similar communities that are noted as those who are deeply impacted first and worst. I think climate change is a result of a very particular way of doing business. This is the massive externality of a chosen political economy. While the result was not intentional, the isolation and or elision of environment historically in our calculus has been predominant and has been purposeful. But that is not the only political and legal infrastructure that I think we can erect. In fact, in the crisis opportunity meme of climate change, this is a crisis, but there is, without a doubt, I would argue, an opportunity. So thank you for the time. I look forward to the discussion.
Okay, thank you very much.
Thank you, Markus. Thank you very much to Simon and Avidan for inviting me. It's a real pleasure to have spent this whole day with you, with some of the visionaries and people that have been working on this topic for a while, and also with some eyewitnesses, direct eyewitnesses like Margareta that live in the Southeast Pacific. The way I discovered the issue of climate-induced displacement was through my PhD that I began already, well, quite a while ago, and I finished about 2.5 years ago. And that dealt with the issue of state extinction due to climate change impacts. So I focused on Pacific Island states because out of, well, the over 133 maybe existing states in the world, perhaps there are 4 that are the most endangered by, in particular, sea level rise, because they're mostly, if not completely, composed by coral atolls or coral islands that are below 10 meters of altitude, and 3 of those are located in the Southeast Pacific, Kiribati, Tuvalu, and the Marshall Islands, the 4th being the Maldives that Alexandra has already mentioned. So I began this research topic thinking that I was basically confronted to a completely unprecedented challenge to the core subject and object of public international law, the state. And although it seemed that it only affected a very small handful of states and very powerless states, states that are completely underdeveloped, states that are geographically scattered, states that seem to have no diplomatic power of leverage, I still felt that from a symbolic perspective, it was a fundamental issue that we will be facing in the years to come and in the generations to come, because it does represent a massive ontological challenge to international law. And so when I began the PhD, I spent half of my time having to justify why it was relevant to actually do it, which I thought was a pretty good thing, because I thought I had found maybe a niche or something like that. And then Copenhagen conference happened, and I happened to be present there. I was assisting the delegation of East Timor, and I remember the last night of the Copenhagen negotiations. It was about 4 or 5 in the morning, and everyone was struggling to get the Copenhagen Accord adopted as a decision of the Conference of the Parties. And it was extremely, it was extremely dramatic in every sense, and we were all tired and all, it was very emotional, extremely emotional. And in the middle of the night, again in a very dramatic way, it seemed that I think it was the Cuban delegate that said that they would oppose the adoption of the decision of the Copenhagen Accord as a decision of the Conference of the Parties, and then the British delegate, using very famous British diplomacy, asked for a suspension of the session before that would actually be done. And so everyone gathered, left their seats, gathered, and President Mohamed Nasheed, the controversial president of the Maldives that Alexandra was talking about, was there. And I remember him crying, like with real tears, crying and begging to the Bolivian and the Cuban delegates, please adopt this. This is my children, this is my grandsons, this is really an absolute reality, an existential threat for my country and for country. So that image really struck me very personally, and somehow remained at the back of my mind ever since, in all the lonely hours of research that followed that time. So how did I embark in this? I basically, of course, began as every international lawyer would do, with Article 1 of the Montevideo Convention. What is a state? And a state has 3 main dimensions, or 3 main elements or criteria, depending on who you read: territory, population, and a government, a government with the capacity to engage in international relations. And so I began studying how sea level rise within the Pacific Island states regional context was affecting each of these 3 dimensions of the state. I began doing research on first territory, because, well, from my perspective, international law, states exist as a redistribution of power into territorial units. So I began by studying the challenge of deterritorialization. That is the first chapter you might see over there. And so how sea level rise affected coastal erosion, and in particular how it would affect the maritime spaces of Pacific Island states as baselines would retreat, and therefore outer maritime limits would retreat accordingly. And I also studied a little bit of reterritorialization strategies that were taking place, whether the purchase of land abroad that Margareta mentioned this morning, whether the possibility of merging 2 states, etc., etc. That field had not been extremely developed back then. There were a couple of incredible scholars, absolute visionaries like David Caron, that had written about it in the early 90s, or David Friston as well. But it was a field that was still to be, properly researched. From that, I began my chapter 2 on the second dimension of the state, the population. Why I consider it the secondly, it was essentially because I see the challenge of depopulation or the environmental stress that Pacific Islanders are living as a socioeconomic consequences of the previously existing deterritorialization challenge. And boom, I enter into that field, and I find that there is an incredible amount of scholarly articles and work for over 20 years on environmentally induced displacement, and as well on climate-induced displacement, and that, of course, there was all this debate on the legal impasse on whether to call them refugees or not, etc., etc. So my focus in there, I thought, okay, let's see how all the works that make a diagnosis of the problem in the international legal order that that is basically ill-suited to deal with this issue of climate-induced displacement, as well as the solutions that have been proposed by scholars. How can they be useful in the in the Pacific Island states, in the region I am studying. And I was quite surprised to find out some things. First of all, there has been a lot, and there is, just like we heard today, a lot of emphasis on the importance and the relevance of the human rights regime to deal with climate-induced displacement. My first discovery was that the two main human rights covenants, the ICCPR, the ICC, International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social and Cultural Rights, are extremely poorly ratified in that region. In fact, it is the region in the world, according to the Human Rights Commissioner, that has the lower ratification rate of human rights treaties in the world. And that is, according to, to the same source, to some extent, well, first of all, because they are very young states, independent states, relatively young. Second of all, because there is the regional idea that you should not ratify a treaty unless you believe that you're really able to fulfill with all your obligations, so that you can you avoid external critique or anything like that. And third, because there was and there still is a culture, well, a clash between human rights, universal human rights standards, and some cultural practices that exist in these states. So, in particular, with regard to family law, to participation of women in communities, and especially to land tenure systems and access to housing, land and property rights. So it is both covenants are very poorly ratified, and this is also despite that the Pacific Islands Forum, which is the main regional forum of the region, does, I mean, from a policy perspective, they do agree that human rights should be promoted in the region, but that does not, that does not sort out the issue that the treaties are not ratified. So I'm not even talking about the enforcement. I'm just saying that they're not even ratified. Now, as opposed to the poor ratification of human rights treaties in the region, all of them are part of UNFCCC and the Kyoto Protocol. In fact, for most of them, UNFCCC and the Kyoto Protocol were the two only international treaties that they have actually ratified. Beyond that, they're extremely active, as you know, because these states do not act alone within the UNFCCC. They act first within the Pacific Islands Forum, and then as part of the Alliance of Small Island States that has an incredible power of leverage within the climate change negotiations. And they also have built up a very strong, they have built up a very strong history of cooperation for climate change adaptation programs in and amongst Pacific Island states. So we have 5 out of 12 Pacific Island states that have national adaptation plans. There is a Pacific Adaptation Climate Change Project, there is a South Pacific Regional Environmental Project, and there are joint national adaptation programs. So for these states that are not active in many ways because they don't have incredible capacities, everything has to do with the UNFCCC, Kyoto Protocol, climate change adaptation programs. It is extremely developed. So in that sense, I believe that every move towards integrating further the issue of migration, whether of climate-induced migration within the UNFCCC context, will be likely to be much more effective for Pacific Island states than anything that works outside of the UNFCCC framework. And that is, I was talking about in particular to national displacement. When it comes to transnational displacement, it also turns out that the Refugee Convention is very poorly ratified in the region. But you would say, well, it's not that important because Australia and New Zealand, which are the two main regional powers, and also perhaps the two states that are more likely to receive requests from climate refugees parties to the Refugee Convention, and still. My feeling when just analyzing the policies that have been taken forward by the most affected Pacific Island states is that they do not want to take the Refugee Convention path. Even Anotetong, who is perhaps the head of state that has more openly and more actively engaged with this issue and has begun negotiations with the Australian government for different migration schemes, etc., has got land abroad. Why the Refugee Convention isn't necessarily positive here? First, because of the victimization that it creates. That is something that particularly to violence reject very much. Second, because in a context of mass influx, recognizing, it can be very counterproductive to have a state that recognizes that most of this population has left, because it can be basically be used by third states that are pretty eager to perhaps claim that that state has disappeared, or that its international legal personality should not be recognized anymore, so that, for instance, all the maritime spaces that those states created become high seas and therefore can be accessed by anyone. So I think states like Kiribati prefer to use bilateral migration agreements, amongst other things, to buy time while they decide what is going to be their position before international fora about what they want their country to be considered or not considered in a post-submergence or post-total depopulation scenario. And so that brings me to my last dimension of statehood, which is government and governmental capacity to engage into international relations. I'm sorry, Markus, because at the beginning you said that this is a panel where we should talk about solutions. And so I was thinking, well, actually, there is my whole argument in this book is that it's precisely to avoid purely formalistic approaches to statehood. And basically, this is a little bit like Brexit. We all want, in the completely unprecedented scenarios, we're all anxious and we want very clear answers about what is going to happen and what is this new situation going to be defined by. But precisely the inherent nature of unprecedented scenarios is that first, they need time to get sorted, and second, what's most important perhaps is to identify who are going to be the relevant actors, rather than think of what are going to be the solutions. And I really always want to focus on basically avoiding Western top-down approaches to these issues and keep an eye on what Pacific Island states are doing themselves for themselves before international fora, because they're very organized, they have a lot of experience about this, they are very active, and try to understand why maybe they will want to continue to defend their continuity as states, as water states. Maybe they will claim international legal personality in a non-state form. Maybe they will agree that their international legal personality has vanished, but before they accede to that, they would negotiate citizen agreements, for instance. We don't really know, but saying that post-emergence and post-depopulation scenarios lead automatically to the end of statehood, I disagree with that, and I believe maybe that is an answer.
Good. Thank you very much. Our final speaker for the day is Camilla Schloss, we're looking forward to your presentation, Camilla.
Thank you. I have the honor or the misfortune, depending on how well you can do times and place, to be the last speaker of this workshop, which has been so interesting and inspiring, and thank you to you all. I applied for this workshop because I wrote a paper which could have had the title of this workshop, with some contextual differences, of course. We wouldn't be in the academia otherwise. I aspire, like this workshop, to tackle, in the words of the program, the legal no man's land in which the issues of climate change, climate refugees currently reside. The paper which I wrote for a class on migration and development, taught by Professor Susan Martin at Georgetown University, has the topic cross-border displacement due to environmental disasters, filling the protection gaps with UN guiding principles. As the title indicates, I don't quite follow the concept of climate refugee and suggest a border protection instrument, but let's discuss the content later. We all agree that displacement due to environmental disasters is one of the defining issues of the present century. And in this workshop, we have pointed out to the weak provisions in the Paris Agreement and the gaps in refugee and human rights law. In my paper, I want to overcome the legal impasse and show future pathways by suggesting the adoption of UN guiding principles. This is about finding an international solution to cross-border displacement, not internal displacement. In the paper, I pose and try to answer two questions. What is the best mechanism, instrument to protect persons displaced cross-border due to environmental disasters? And secondly, what should be the content of this instrument? I will focus on this presentation on the first question on the legal instrument, and regarding the second question, I will discuss how best to derive the content of the legal instrument. I shall restrict my comments on the actual content to some general remarks if there is time. In the paper itself, I will formulate some of the provisions in detail. So, what is the best legal instrument? As my title implies, I suggest a soft law protection mechanism, the UN guiding principles on cross-border displacement due to environmental disasters. Why a soft law instrument? Why not a hard law instrument, like a new convention, or the enlargement of the refugee definition, or protocol to the UNFCCC, as other scholars have suggested? Soft law mechanisms have gained popularity. The international community has made increasing use of them. One relevant example are the already mentioned UN guiding principles on internal displacement. They have been developed by the representative of the Secretary General on Internally Displaced Persons, who acted on the request of the UN Commission on Human Rights and the General Assembly. The two institutions took note of the guiding principles in resolutions in 1998. The guiding principles do not constitute a binding instrument, but should provide guidance to states and to other authorities, while they shall not be interpreted as restricting, modifying, or impairing existing rights and provisions. The Nansen initiative, which has also been mentioned already, has also started a discourse going in the direction of a soft law mechanism for cross-border displacement due to environmental disasters. Launched in 2012, the Nansen initiative has its origins in the pledge of the governments of Norway and Switzerland at the UNHCR Ministerial Conference in 2011. The Nansen initiative considers itself a state-led, bottom-up consultative process. Its goal is to build consensus on principles and elements for addressing the needs of people displaced across international borders in the context of disasters, including the effects of climate change. It undertook a series of regional intergovernmental consultations and civil society meetings. The outcomes were consolidated, as you may know, in the non-binding agenda for the protection of cross-border displaced persons in the context of disasters and climate change. The agenda was endorsed by global intergovernmental consultations consisting of ministers and representatives from 110 delegates in October 2015, so last year, as a guiding document to better conceptualize cross-border disaster displacement. The agenda entails a section on admission and stay of cross-border displacement, elaborating the effective practices, background information, and gaps and challenges. It ends this section by pointing out gaps and challenges and stresses most states lack laws and policies that would provide criteria if cross-border displaced persons arrived at their borders. The success of the agenda can be acknowledged, for it managed to get many states to come to at least some form of agreement. However, the Nansen initiative falls behind establishing explicit and defined rules, and therefore we need to work towards another legal mechanism. While the agenda acknowledges the need for action at national, sub-regional and international level, it only mentions existing practices which can provide inspiration to states and other relevant actors. The agenda does not mention specific international applicable principles, nor does it expressly aim at developing such in the future. It rather emphasizes affected states' primary responsibility to prevent and respond to disaster displacement, and the importance of harmonizing approaches at regional, not international level. The international community should follow the footsteps of the Nansen initiative and formulate more precise UN guiding principles. Given this context, soft law mechanisms have the following advantages. At a time when international action in this field is urgently needed, soft law mechanisms are a more feasible solution compared to an international convention or the reopening of the debate on the refugee definition. It is easier to make states agree without express legal obligations, obviously. And the fact is, states are currently unwilling to do more. Assisting states are wary of surrendering their sovereign prerogatives. The international responsibility to host in some form or the other displaced persons contravenes the principle of state sovereignty, as has been mentioned already, which is, as you all know, one of the foundations of the UN Charter system. Indeed, often migration law is perceived as the last bastion of sovereignty in the repeatedly expressed predictions about the demise of sovereignty. That's why it is so hard to tackle migration. As it might be too early for a hard law mechanism, not only from a political point of view, but also for substantive reasons. With soft law mechanisms, states can maintain considerable freedom of action. They allow states to experiment with new ideas. This flexibility might be useful at this point of time, when we have not yet fully captured the extent, definition and content of the protection of climate refugees. We are lacking knowledge and data, which has also been mentioned a couple of times here. In fact, in a conference at the World Bank recently, all speakers acknowledged that the data and knowledge is insufficient. Also, the Nansen initiative names collecting data and enhancing knowledge as one of the 3 priority areas for future action. UN guiding principles could ease the path to a more effective hard law instrument through building a forum for trying out different mechanisms, through improving the basis for international cooperation, and through harmonizing national laws. And in general, migration law resembles a patchwork which would need, at this point in time, more innovative tools than crafting a new multilateral fragmented treaty. Soft law can have an effect, albeit the lack of an express legal obligation. We can draw on the UN guiding principles on internal displacement as a good example. The international response has greatly exceeded the expectations. At the international level, the UN guiding principles have received wide endorsement by international organizations and also by states who have incorporated these UN guiding principles in their legislative and policy framework. The strongest influence can be seen in the Kampala Convention, which has also been mentioned already in this conference. A similar effect can be expected from the UN guiding principles for cross-border displacement. Finally, soft law mechanisms have also an important consciousness-raising function. Through soft law mechanisms, different domestic, political and civil society groups receive a platform to lobby and bring inside change in the country. In the last 5 minutes, I would like to focus on the content of the UN guiding principles by asking the questions: what is the process of developing the UN guiding principles, and what should be their content? In developing the substance of the UN guiding principles on cross-border displacement due to environmental disaster, we do not have to start from zero. We should try to include already existing legal instruments and frameworks. In line with the propositions for hard law mechanisms, the UN guiding principles should draw on and seek to be consistent with existing human rights and humanitarian law. This is similar to the way in which the UN guiding principles on internal displacement were drafted. existing domestic and regional regulations such as the African Union Refugee Convention from 1969 can also be included. For the definitions, we can make use of the agenda of the Nansen initiative, and especially for the definition of disaster, we can also revert to the ILC draft articles on the protection of persons in the event of disaster, which have also already been mentioned. The Refugee Convention and the UN Guiding Principles on the Internal Displacement can serve as an indication of what rights, protections and assistance are relative. I see the UN Guiding Principles as a migration instrument related rather to migration law than to environmental law. However, I would like to question the use of the term refugee, as this term is strongly related to the Refugee Convention. We've had this discussion also today. Finally, some general remarks on the content. Substance needs to be given to the UN Guiding Principles, both in terms of legal conditions for the protection as well as the legal consequences of granting such protection. To set the legal conditions for the protection, I suggest a very broad scope, which includes all forms of disasters. Natural disasters should be formulated broadly to leave flexibility for future scientific understandings of impact, and should not cover certain types as has been suggested today. Disasters should include sudden onset and slow onset natural disasters. This proposition aims to regulate displacement due to environmental disasters without requiring a causal link to climate change. We've discussed this also. The main argument is the multiple causality and that it is hard to prove the link to climate change, as well as that the need of protection derives from the vulnerability of the affected persons and not of the cause. Okay. Finally, regarding the legal consequences of fulfilling the protection, in line with many suggestions here, I propose an individual rights-based approach and would like to also follow the principle of non-refoulement. This is a brief recapture of my main points of my paper, and I'm interested in hearing your opinion. Thank you.
Thank you very much.